Good morning, Cindy.
Morning.
Cindy, yesterday, are we by ourselves? Oh, no.
Mr. Freeble's on.
Okay. Did Chester Gonzalez reach out to you yesterday?
No.
Okay. You were trying to get a hold of him, ¿verdad?
Oh, no, I was asking if he subpoenaed Mr. Trevino. That's all I needed.
No, he didn't.
But he
Judge
did.
ordered it.
No, he
Judge-
did subpoena. No, he did subpoena him because his employer has a record of it, and he was on
But-
Zoom. He just didn't testify.
Oh, but Chester called yesterday and told me that to let you know that he did not subpoena him. That judge had asked to be subpoenaed, but apparently he showed up.
No, I know, but his work, Mr. Trevino's work, has a copy that a subpoena was issued to him. That's why they need the copy of the transcript where they talked about it. They need every transcript that they talk about it because the internal affairs is investigating him or something.
Yeah.
Did you get Amber's exhibits and Mr. Salazar's exhibits?
No. Oh, well, no. Amber's going to show him just on Zoom. That's what she said. Did you get a copy of it?
Yeah, I got them all, but
Okay. Mr. Salazar filed them late yesterday. So I just asked Brenda to print them out and put them in the file also.
okay.
Is Brenda there already or no?
No.
Okay. Is it a lot from Mr. Salazar?
I don't know. I didn't open them.
Oh, okay. Well, I'll call Brenda to make sure that she print them out.
Okay.
Thanks.
Unlimited. Worst case scenario, the judge cut you down to minimum wage of $250. So you're in no worse condition than you are today. Oh,
Oh, no, doesn't matter. Give them over here. Okay, put it here.
Let me see. Okay, the judge is here.
Everybody hear me?
Yes.
Yes.
Good morning. The 57th District Court will call its court into session for today's session, Thursday, January the 27th at 2022 at 8 o'clock in the morning. Beginning with tax suit 2021 DCL 967, Cameron County versus Doyle Clark.
Good
Mr.
morning, Your
Clark,
Honor.
He's here in the courtroom, Your Honor.
okay, Ms. Curiel. Mr.
Yes, Your Honor. Good morning.
Mr. Clark is present in my courtroom Zoom and so where are we on this matter?
Perfect. Thank you, Your Honor. My name is Ariana Curiel, just for Mr. Clark. We represent the governmental entities, which is Cameron County in this case. And we have filed a lawsuit for delinquent taxes. I do see the delinquent taxes have been paid, Your Honor. It's just fees pending. It's $570 of fees, and that is court costs and the citation fees, Your Honor, that just need to be paid. So it's a small amount. I'm not sure if he was still willing to pay that. We can work with him. He can't pay that in full, Your Honor.
All right, Mr. Clark,
Yes, sir.
what is your response to their proposal?
I'm happy to try to pay all kinds of fees if necessary to buy myself a little time to resolve this matter.
Well, I believe the payment of the fee would resolve it. Right?
Pardon me?
Ms. Curiel, the payment of those costs that you're asking for would resolve the issue?
Yes, Your Honor, we will close out the case once he pays those fees. If he can't pay them in full, we can do partial payments. It's $570. I'll give him our office number. Mr. Clark, you can contact our office and that's where you can pay them, or you can just call us if you have any questions regarding those fees.
Okay, let me,
Can I have the number?
Yes, absolutely. It is 956.
Hold on a second, lady. He's getting something to write on.
Oh, I apologize.
I'm writing it down.
Oh, go ahead. The bailiff is writing it.
956-546-1216.
Got that?
yes, I do. And I was gonna write the lady's name down, if you want to give me a second.
Yes.
Yes, that is Ariana. Last name is Curiel, Curiel. You can speak to anybody here at our office. If you want to
Okay.
speak with me, I'm just going to probably be in court this morning, but you can go ahead and call this morning and anybody else can help you.
Okay, I appreciate that. Thank you.
And you better hurry up before that name changes to Ariana Curiel de Magallanes. I've forgotten, huh?
It's
Anyway,
coming up. It's coming up.
you got that, Mr. Clark?
Yes, sir, I do.
All righty, sir. Have a good day and take care of it and they'll resolve the whole issue. Thank
Okay,
you.
thank you.
We don't need to reset it, Judge?
I'll leave that to Ms. Curiel. If he doesn't pay, then she can get back on the docket.
Your Honor, we could just have a date for our security,
Give me a date.
just so it won't get lost in the docket. I'm sure Mr. Clark will pay these fees off.
All right, give me a date.
Okay, February 10th.
February 10th.
Thank you, Your Honor.
Thank you. 2019 DCL. Thank you, Mr. Clark.
Thank you, sir.
2019 DCL 7307, Cameron County versus Emilio Trevino, Mr. Janas and Ms. Curiel.
Yes, Your Honor. Good morning. Again, Ariana Curiel on behalf of the plaintiffs on this case.
Judge Nathan Janis on behalf of the respondents.
What do we have on this one?
Your Honor, I believe the taxpayers are here, or at least the heirs are present for this case.
That is
Okay.
correct, Judge. And I spoke with Mr. Martinez and his wife, the heirs. Essentially, Judge, they want to remain in the house. They want to stay there. And I just advised and I made contact with them that they need to go and be put on a payment plan. Basically, what I'm asking this court for is just some time for them to reach out to the offices so they can set up, and, you know, with COVID and everything, and it's been difficult. So we just need some time, Judge.
Well, okay, Mr. Martinez
Yes, sir.
and Ms. Martinez.
Morning, Your Honor.
Good morning, both of you. How much time do you need, you think?
I would assume, depending on how much I would have to give down, or what payment plan they can put me in.
Ms. Curiel, what is the balance on this one?
Your Honor, the balance on this one is, let me double check.
It's about $6,000,
Yes,
Judge, plus or
a little
minus.
over- Yes, a little over $6,000, Your Honor. I know they came into our office yesterday. They were saying that they were gonna make a payment, or we're looking into getting into a payment arrangement. So it just depends how fast they can make that first payment. It's up to them, Your Honor. We're willing to work with them.
Here's what I want you to do and think about doing, okay? If you can come up with a, say, $800 initial payment, and then set up an installment that you can work with. It's not, Ms. Curiel, I know you don't handle these personally, but I would like to make sure that I'd ask to prevail on you or your staff to see if we could set up a payment plan for these folks that are not set up for failure. You know what I mean? If you're gonna ask them like $2,000 every 2 weeks, that ain't gonna happen, and you know they're gonna fail. So let's be a little bit more realistic about their finances, their situation. They're gonna make an effort, and their first good effort is gonna be a good faith effort. And then for that, I hope that your office will work with them to give them a reasonable payment plan so they can rescue this property. Whose property is this, Mr. Martinez? Yours?
Yes, sir.
Okay, Ms. Curiel?
Yes, Your Honor, we'll work with them. We have explained what is needed for a payment plan, but nonetheless, if they can't afford getting into, or that chunk of money, we usually ask for a third down for a down payment. We'll still work with them. We won't reject any payments.
Okay, all right, you heard that, Mr. Martinez. I'm gonna give you, give me a setting for this matter in August.
August?
That should be sufficient time to work it out with it. And to have
Let's set it up for
if not
for
eliminate
August
a serious debt.
25th,
But what is it?
August 25th.
August 25th. All right,
Yes, sir, Your Honor.
thank you,
Thank you.
Honor.
Appreciate it.
have a good day.
You do the same,
Likewise.
thank you.
Thank you.
Thank you, Mr. Janis.
And judges, that concludes my business. Permission to be excused?
For a little bit, you're coming back, right?
No criminal docket today, Judge,
Thursday.
You're good. You're very good.
but
You're
I'll be
really
back. I got my rooster for
I-
tomorrow morning.
That's the only. Well, you know what? I think I've been waiting for Miss Rodriguez to falter there, so I could send her one of my favorite roosters. But she's
I
on
was
this
gonna
one.
say, hey, where'd you get that from?
She's one of my roosters.
That's because Amber's always on time.
That's right.
Let's
That's
say
why
that
I'm
I
saying
don't have
that.
one, right?
She's making a concerted effort to avoid me delivering one of those special Federal Express packages that contains a live rooster.
She's always on time.
All right. Well, thank you, Mr. Janis. Appreciate your help.
I'm
course,
too
Judge.
scared not to be on time.
All right. Let's go with the divorce here. 2021 DCL 4433. Terrain Lee Camarillo and Erosia Guadalupe Camarillo.
Good morning, Your Honor. Randall Fraple for the
Erosia
petitioner.
Camarillo. Okay, are you there, sir?
Yes, sir.
All right. What's going on this one?
Your Honor, basically, we have a dispute over child support.
Okay.
We're
Because
ready.
the dispute arises out of the fact that he disputes the income you're basing it on, or what?
Yes, Your Honor. Basically, we are requesting child support based upon Mr. Camarillo's past earnings. We have filed 2020 income tax return and his 2020 bank statements. And we believe his deposits into his bank account show a income substantially more than he is claiming.
Okay, Mr. Camarillo,
Yes, sir.
what's your response?
As described to him, if he compared the notes, that my income is actually true, and that the money that was excess was due from sold trailers, as well as money given to us from my ex-wife's or future ex-wife's gift, wedding gift. It was supposed to pass through us and give it back to her for 20,000. So if you look at the math, it's all there.
Your Honor, we
As-
have.
As well as I no longer work at that company. and I now started my own company, and my income isn't as great as it was.
What do you do, Mr. Camarillo?
I'm an RV technician.
Okay, how long ago did you start your company?
Earlier this year,
And what precipitated that move?
once Taryn removed me from the household, I basically just broke down for a couple months, didn't know what to do, and decided to move. Started my own company.
Your Honor, our exhibit number 14 is a recapitulation of his deposits into the Wells Fargo account.
Let me do this, Mr. Freebo, because of the fact that I don't have I gotta be honest with you, I don't have any of your exhibits in my file. I didn't say, I'm not suggesting you didn't file them, but here's the other thing that a lot of the attorneys are failing to do is they're failing to file them with my court reporter, send them to my court reporter too, because she needs that as the official custodian of our records of the court. The official exhibits in her hands, they're entrusted. She's responsible for those. So she needs to have those. Have you favored her with a copy of that?
No, Your Honor, they have been filed with the papers of the court.
So could you, I want to go ahead and pass this for a little bit until I get the exhibits myself. I don't have them printed in my file. I need to refer to them as you're talking to them, telling me to look at this, look at that. I need to do that. So if you give me a second, let me give my staff a time to go look for them and copy them, download them and copy them for me, and also for you to send them to Miss Cindy. Okay? And
Yes, Your Honor, may I have?
Camarillo, don't go anywhere. We're gonna reconvene in a little bit. I'm just gonna finish the rest of the case so I can listen to this more carefully and slowly, okay?
Okay, do I need to send my paperwork as well? Because I have everything here on my computer. I wasn't sure how this works.
Well,
Yeah, you have exhibits as well?
yes, hold on a second and then write that down because you're gonna get instruction how to do it.
Okay, thank you.
So if you have exhibits, you're just going to email them to me. My email address is carrace24@yahoo.com.
Thank you very much.
Thank you.
And I can get them faster than when they're e-filed, so.
Oh, yeah, tell them I'll be right with it. Yeah, tell them I'll be right with it. Miss, okay. 2021 DCL 2549, Guajardo Martinez. Is this Mr. Salazar? If I recall this was reset for the purpose of allowing Mr. Salazar to formulate additional evidence regarding the contributions to the improvement of the separate property that his client is subject to reimbursement for. Is that right, Ms. Rodriguez?
Yes, Judge.
Mr. Salazar?
Yes, Judge, and we submitted an appraisal that details the current market value of the home. And it also details the floor plan of the home. And basically our argument is that, the home clearly shows that the improvements are there. The value of the home shows that it's $118,000. And we plan to argue that the square footage of the improvements that were made during the marriage, as the court has ruled, should be calculated at
let me
yeah.
just, I may need to also reset you for a little bit. I don't have any of those things that you filed do you have them, Cindy?
No, they're in the file, Judge. Brenda printed them yesterday.
All right, well then I need to look at those because I haven't had a chance to look at that and I'll have to review that while we talk. But let me ask you just a matter of information for me. After you calculated according to how you read the law and how you see the right to reimbursement, Salazar, what are we looking at as her divided, the total amount of a contribution and her share of it? So what are you suggesting?
So the amount of improvement that was clearly done in 2015 by Cameron County Court Records that has been previously introduced was a total of 628 square feet to the building of the separate property of Mr. Martinez.
Okay.
So we are arguing that 628 square feet of that property, of that home, is should be, or the value of that should be
I understand
reimbursed to
that.
the
So what
community.
value do you attach to the 625 bill as being a contribution that, I'm assuming that half of that, because,
Well, so the way I'm gonna argue it, Judge, is if we go by how the appraisal appraised the home, it appraised the home at $95 a square foot
okay,
for the living area. And the living area does not include the additional property because it's not improved. So when they appraise it, they don't necessarily kind of,
well, they value the structure on the property.
yeah.
Yes.
Yeah, so they valued it at that. So if we go by that $95 value, 628 square feet by 95, that's 59,760. Although I think the more appropriate value is if we look at the notes on page, I believe 10 or 4 of the appraisal, the appraiser does note there that living area adjustments are based at $60 per square foot, being that these 628 are not fully improved. There still needs to be work done on them. I think a $60 square foot valuation is more appropriate. And if we do that math, 628 by 60, that's a value of 37,680. So our argument is that the reimbursement to the community should be on the low end, 37,680, on the high end, 59,760.
Right, but so the 37,000 and the 60 whatever thousand that you come up with, that is gross. That's improvement that is based on both of their activities,
Yes.
right? So 37,000 low end would be half of that, 15,000.
Yes, that would be, and then once we get to that actual value, Judge, we would argue for half of that.
Okay. All right, got it.
Judge,
I'll give you a chance to respond, Ms. Rodriguez. I just want to make clear where Mr. Gonzalez, I was going. I'll come right back to you so you can respond appropriately. Let me just finish the rest of the docket so I can clear up and give you plenty of time to do that, okay?
yes, Judge.
Thank you. 2017 DCL 1913, Laura Torres, Cesar Julian Torres. Mr. Afternoon.
He was on there.
Hello.
Where'd he go?
I don't know if the volume's low.
I don't see him on here.
I don't see him on there anymore.
Laura Torres. Okay. I don't see Mr. Afternoon was on here, Mr. Garza, but I don't know where he went to.
I don't know.
He might have gone to another court. I'm not sure. He didn't say anything before he left.
You're the only one starts at 8.
I am?
He was on, I think he was on in his car though. Maybe he went to his office.
I don't know.
He's having liver issues.
What is this about? Ms. Moore and Mr. Garza, since I have you both here.
It's about credits, Your Honor, that Mr. Torres would be entitled to in terms of child support payments.
Okay. Ms. Moore, have you consulted with Ms. Moore in the AG's office regarding this?
Not Ms. Moore. I know Mr. SMU had provided me some bank records for us to review, and we did, and we have numbers. I can share that information with Moore while we wait for him.
If the child support went through Ms. Moore's office, I think she's essential to that discussion, yes. Ms. Moore, did they go through your office?
No, Your Honor, they have not consulted with me, but if they want to give.
But did the payments go through your office? Did the payments go through your office?
Yes.
Okay, well, yeah, we need to talk to Ms. Moore and figure out where she's at on this.
Yes, Your Honor.
Do you want me to send you a breakout room?
Yes.
That's good. Thank you, Judge.
Send Ms. Moore and Mr. Garza to a breakout room, and if Mr. Efthimiou appears, send him there too, please.
Okay, hold on. Okay, the room is open.
Thank you. All right. Mr. Curiel, I'm sorry, I should have called your case. I didn't see this at the bottom of the, you have one more. Tech 2021 DCL 1154, Cameron County versus Nereida Quesada. Nereida Quesada. Okay, no answer.
Thank you, Your Honor. We're ready to proceed on this one. At this time, we are asking the court to take judicial notice of all the documents in the court's file. We are asking that judgment be granted an amount of $1,356.30. We brought this suit on behalf of Cameron County for delinquent taxes owing for the years of 2015 to 2020. Ms. Nereida Quesada was served, Your Honor, and that was personal service back on May the 25th of 2021. We had included another tract in this lawsuit, Your Honor. However, we have partially non-suited that tract, and that was done on December 31st of 2021. So we are proceeding just with tract 1, and we're asking that judgment be granted, and we're offering exhibits A and B. Exhibit A is a certified copy of the delinquent taxes for the county, and exhibit B is an affidavit of non-military status.
Okay. The court will take judicial notice of all documents in this case. The court will admit the exhibits that have been tendered by the plaintiff. The court having called out the name of Nereida C. Quesada. No answer having been had. The court hereby grants a default judgment as prayed for.
Thank you, Your Honor.
Thank you.
Your Honor,
Yes, ma'am. Thank you.
I did have another one.
Which one?
And 2020 DCL 05997 Merck's Enterprises, and I see Ms. Guzman present.
Oh, I did. Oh, I'm sorry. I skipped that, Ms. Curiel. Why?
I'm not sure, Your Honor.
What's wrong with me? Sorry about that. Cameron County versus Merck's Enterprises LLC, also doing business Los Dos Angeles ADC.
Yes, Your Honor, that's correct.
Okay. Sorry about that, Ms. Guzman. I didn't mean to.
It's okay.
All right.
Oh, no problem.
Proceed. What is going on with this one?
Your Honor, on this one, I believe we had been here before. There were some issues with the appraisal district that Ms. Guzman was contesting, and she was going to go to the appraisal district just to figure out from what we've been in communication with. She's been in communication with our office, and we had explained, or she had explained to us, that the business had closed in 2019 or 2020, if I'm not mistaken, but she'll speak on that right now. And the taxes are still accumulating, Your Honor. I believe her business closed in 2019 and still taxes for 2020. There's
how is that? How is that?
Your Honor, a record owner, whenever a business closes, needs to attend the appraisal district and file a rendition or file, I don't know what documents that they need in order to close out the business. If not, taxes still accumulate. And this is business personal inventory, Your Honor. So we directed her that way. However, there's delinquent taxes prior to 2019 that are still delinquent. So we're willing to work with her, but I know she wanted to get the appraisal district issue resolved first and then pay the taxes. So I'm not sure where she's at.
Okay. Ms. Guzman.
Yes, that's correct, Your Honor. I called the appraisal district, and they did tell me that I needed a letter from the landlord that used to rent that office space for us. I know that the business completely closed in September the 1st of 2019, because that's when I moved my patients out of the adult daycare and transferred them to another adult daycare. I haven't been able to get a hold of the landlord to be able to get that letter. So I can, the only thing that I have right now, it's a letter that was sent to me by the Texas Department of Aging and Disability when I let them know that I was closing the business, but I didn't receive a response until December of 2019. So they said that because it's in December, they couldn't go back until September 2019 unless I had the letter of the landlord. So I haven't really been able to move forward with anything like that because I haven't been able to get a hold of anybody. I've been trying to leave messages to the landlord, but I haven't had a response yet.
And so all this is tax for inventory?
Yes, Your Honor.
Yes, it is, Your Honor.
It's business personal inventory.
So you continue to tax the inventory unless we show you proof that we are no longer in business?
That's correct, Your Honor. And that would be with the appraisal district. They're the ones that appraise these.
Well, you know what? I need to do that too then.
Yes, Your Honor.
Yeah, because I closed my law office, but I've never done that. But
Yes.
I have to go to the appraisal district and tell them that I've closed my office. I don't know what they need from me, but I guess they'll need something. I
Yeah.
was the owner of the building. I just sold it, so I definitely am not there anymore, and haven't been here because I've been here close all this time. So,
That's
can you favor me with this? Can you, Ms. Curiel, tell me what section of the tax code or your code that talks about inventory and appraisement and the responsibility on the taxpayer to do what you've asking us to do?
Yes, absolutely, Your Honor. If you can just give me a minute
Sure.
and I'll pull it up.
Oh, Mr. Effemy's coming in. Let me send him into the breakout room. Mr. FMU, I'm going to send you to the breakout room with Mr. Garza and Ms. Moore.
Okay.
Okay, it should be prompting you to join. Okay.
Thank you.
Welcome.
Should I download this introducing Zoom apps, Discover?
No,
app
no,
to
no,
enhance
no,
your-
don't do anything.
Do I want to enhance my Zoom experience?
No, don't touch anything. Or it throws you out.
Yeah. Yeah, you better not let me touch anything, because
Don't touch your computer.
the whole screen will go dark immediately. Well, it sure is tempting. It's prompting me to do it. I gotta tell you that.
Don't do it. I've gotten everybody's exhibits already too.
Okay. Yeah, I have a large packet of them.
Okay, let me send them to Norma so she can print them for you.
Which ones are you talking?
No, for Mr. Freeble and Mr. Camarillo.
No, I have.
You should have them.
I have them.
Oh, you do have them.
Yeah. Brenda just gave me a copy of all of them.
Okay.
All right. Ms. Curiel, it's no big deal. I mean, if you want me to, you can just get it to me later.
Yes, Your Honor. I'll go ahead and give it to
Okay.
you. I'm looking at section 31.081, and that's business inventory, but I'll go ahead and give you a little more detail on that. I can send that over to you just with
appreciate it.
more information. But
Okay.
I am seeing it's 31.081 business inventory property tax.
Okay.
It's in the property tax code.
Got it. Okay. So what are we doing now, Ms. Guzman, with this matter?
I need to get a hold of the landlord. That's my first step to be able to move. I know that when I had called the attorneys to be able to resolve this, they were asking for a certain amount to be given us down, and I couldn't afford it at that time. I'm up and running again with my job, and I was looking to see if I could get some installment plans. Meanwhile, I am able to fix the 2019, because I know after I moved out, those offices rented out immediately. So everything, because I rented the whole building, and when I moved out of there, they immediately were separated in between individual offices. So they were placed to rent right after I moved. So
Okay.
I don't know. Before, they used to charge me because I had the vans for the daycare. And since I moved, there hasn't been any vehicles parked out there that say adult daycare. So I'm not sure exactly how I'm going to move forward with this. I need to step into the appraisal district again.
Well, so how long do you need?
I could start doing it today, as of today. I asked for the whole day off today so I can.
So what are you inconvenienced, Ms. Curiel, if we give her an opportunity to see if she'll find her landlord, get this thing straightened out, and then you end up at a final figure?
Yes, Your Honor, we're not opposed. I know if the appraisal district gets this resolved, they might just delete the 2020 year and forward, if not 2021 and forward. However, they're all delinquent taxes since 2015, and I know the business was closed in 2019. So we're willing to work with her. If you can't get into an installment plan right now, we'll accept any payment, Your Honor.
Well, then, I guess so then what I'm hearing is when you were in business, you were owing taxes, so you need to pay
Yes,
those.
that's correct, Joe. Yes,
All right, so
that's
if
correct.
you address those with them, I think that the rest of it, we can, I can give you time to work out. Okay?
Okay, Your Honor. Yes,
All right.
thank you so much. Thank
All
you.
right, so let's reset this matter for 6 months.
Okay.
Let's,
Hala.
yes, I'm gonna go ahead and set it up for the 30th of June.
June 30th. All right,
Thank you, Your Honor.
have a good day.
You too.
Thank you, Your Honor. That is all I had
Is
for
that
today.
all?
You may be
Okay.
excused.
Josette, Angelique Cruz, Rick Cruz. Okay, we passed that.
Okay.
Mr. Freeble and Mr. Camarillo, I've got the exhibits. You just gotta give me an opportunity. I need to meet with somebody really short. And I've got the exhibits, so I need to also review them. Why did I froze?
Rose?
I got my exhibits here, they're voluminous, but I'll review them. But I need to meet with somebody right now, real quick.
Very well.
Can you mute me?
Yes, I'm gonna mute you, and that's it.
Brenda, Brenda, on Torres versus Torres, 2017 DCL 1913. I had already print out the Exhibit A del Attorney General. I don't know if he's got it in the file. But you want to print it out for me just in case he doesn't have it. It's Exhibit A y es el donde está todo lo que le está pagando al Attorney General. Por favor. Okay. Thanks. Bye.
Hello, Cindy.
Yes, sir.
How are you?
I'm good. How are you?
It's fine.
I don't believe we'll need you for this last two cases.
Okie dokie.
So go to another court if you need to.
Thank you very much. I was about to ask you that. Thank you very much. Have a great day.
You too. Bye-bye.
Cindy, did you get my exhibits? This is Amber.
Yes, I got what you emailed me.
Were you able to print it or did it need to be printed? I know it was a lot.
Whatever you sent, I believe Estella had Brenda print it for the judge. And then what you sent me, let me see. What'd you send me yesterday?
Amber, did you send me something?
No, I sent it to only Cindy last night.
Okay.
I have it, yeah. Let me see. Is it just the one? Respondents Exhibit 1?
It's the list with all of the exhibits attached to it. In it, like all in one document.
Let me see.
But are you going to show them to the judge through the Zoom?
Yes.
Okay.
So majority of it he should already have because we've been doing it so long.
Let me see. I got your exhibits. Oh, that was from the previous hearing. Sorry, Rob.
I sent it last night around 8 or 9.
I got that one. Let me see. The 49 pages, right?
Yes. I think.
It's the one that says responding exhibit. Yeah.
Yes.
Okay. I can send it to Norma so she can print it.
Okay. The only thing new in that one is the pictures.
Okay.
And exhibit 2. But yeah, it's that. That's it. Thank you.
No problem. You're welcome.
Cindy.
Yes.
Did you get my list for tomorrow?
Yes.
Okay. The one the florist. That one, don't send it to them. That's on Elliott Electric Supplies. It's a summary judgment. I shouldn't have sent those names to you.
So just the David Flores?
Flores, and there's another one. I think it's can't find it's a Dallas guy. Beanland.
Which one?
Beanland.
Okay.
Okay. Those two.
Cindy, this is Randy Friebel. Is sending the court reporter the exhibit something that is unique to the 357th, or is this required from every court?
Oh, she was there.
Hold on, Judge. Let me print one exhibit that Amber sent last night. More now? Well, Amber sent it last night, but I thought she had sent it to the court too. She just sent it to me. So I'm having no more printer real quick.
Well, let me get going on the other one. Oh, well. Now you know how I feel. Now you know how I feel.
I need to be put into a certain place while you're doing that. Mr. Hiroshi, can you call him, please, Ms. Carranza?
He's right there.
Yes, sir.
All right. So, Mr. Freebo, your calculations in the last pages contain your exhibit list. I want to understand them. You're telling me that after you made all the calculations, gone through Mr. Camarillo's bank statements and what have you, you've come out with net disposable income of $33,000. Is that right?
Yes, Your Honor.
And from that, you extrapolate from 33,000, you apply the child support guidelines?
Yes, Your Honor, that's based on exhibit number 15.
So according to that guideline, he shows monthly net earnings of
4,466.
and you net it out to $3,478, right?
Yes, Your Honor.
So if I multiply that times 12, that's more than the 33,000 disposable income that you show on the previous exhibit. Do you understand what I'm saying? If I just take your net income that you've come up with and multiply it times 12, which is 12 months, that's more than 33,000 disposable income that you came out with in the previous exhibit.
You're correct, Your Honor.
So that this is not jiving. This does not, to me. So why don't we go back and allow you an opportunity to revisit those numbers and then come out, and they might come out in an amount that Mr. Camarillo may be, it might be more palatable to the amount that it really is on, if we do it based on what your calculations show to be his net disposable income.
Yes, Your Honor, I'll run it through my calculator right
right.
now.
I'll get right back to you. Let me just get back to the other one real quick so that I can run both of you together, because the other one has another exhibit. So I'll just mute yourself. Mr. Camarillo, don't go anywhere. All right. Ms. Rodriguez and Mr. Salazar.
Yes, sir.
All right. Ms. Rodriguez, I promised you an opportunity to respond to Mr. Salazar's contention.
Okay. Sit tight. It's two-part. I ask you to bear with me. So, as you know, Your Honor, this is probably the fourth final hearing that we've had in this case.
And this will be the final hearing.
The first time, Mr. Salazar was granted leave to amend his pleading because he had not included a reimbursement claim. He then amended his petition to include a reimbursement claim. We appeared. He determined that it was determined that he needed an appraisal. We were set for hearing. The appraisal wasn't ready. We were reset today for him to get the final appraisal by Mr. Ken Bruce. Judge, I've got to go back to my initial argument that I've made now for maybe the fourth time, or second time maybe actually, in that if you go back to Mr. Salazar's petition, his claim for reimbursement, and I'll read it to you, is that petitioner requests the court to reimburse petitioners, Ms. Guajardo's separate estate for funds or assets expended by Ms. Guajardo's separate estate for the benefit of respondents' separate estate. That means that she's claiming that her separate estate spent money on Mr. Guajardo's separate estate, and that she should be reimbursed for those expenses. Nowhere in this reimbursement claim, in her petition that is before us today, does she mention any reduction of a secured debt, which would be a reimbursable claim under the family code, nor does she mention any capital improvements made to the property that enhanced the value of his separate estate in this petition. That is the paragraph that is before us, is her separate estate expended funds and she wants to be reimbursed for those funds. So in order for her to prevail, even on that claim alone, she would have to prove to the court that she expended her separate funds, which there's been no evidence of the voluminous exhibits that we've submitted to the court so far that she expended her separate funds. I would like the court to bear in mind that these people are both receiving Social Security disability benefits. And as the court knows, those are the separate assets of each party and they're not divisible by the court upon the divorce. So another thing that the testimony and the evidence has shown at the previous hearings when you were determining whether or not they were married, they have kept their funds entirely separate. Ms. Guajardo and Mr. Martinez have never shared a joint account. They've never filed joint taxes. Ms. Guajardo admitted that she had not contributed to any of the bills monthly. They had separate funds. Even if this court found they were married, they had separate funds. So even on that claim that's based in his petition alone, it falls short. She has not proven that she has expended money on this property, period, that she should be reimbursed dollar for dollar. That is what her petition is requesting. And that's what the court's ruling should be limited to. To order otherwise would not be a judgment that conforms to the pleadings that are before us. Okay, second part. Even if the court were to, and again, Judge, this is not the first time I've made this argument. And Mr. Salazar has had at least 2-3 months to amend this pleading to include the correct reimbursable claim, and he has not. Next step, even if after you gave Mr. Salazar basically a Judge Magallanes mini CLE on reimbursable claims, which he didn't heed because he didn't amend his pleadings, even if this court were to go with capital improvements made by an estate for the improvement of his separate asset, we've got to go back to the specific prongs of that type of claim. If you did allow that type of claim, first of all, he would have to prove that the community estate expended money on capital improvements to this property that enhanced his separate estate. First step falls short. They never had any community funds. She's not provided any exhibits where the community has expended funds on any capital improvement. Any money that they've ever had is their Social Security income. Second, to that same prong, my client will testify that what it is, and I have produced exhibit, I would like you to see the video footage, and I would like you to see the photos of this unfinished house. My client will testify, and I think that the exhibit 2 of respondents, the builder's permit, shows that he applied for the building permit in 2009 prior to their marriage to initiate the second floor. And what it is, and he will testify that there's two parts of the building that were added on. Downstairs area, which I want to say is about 445 square feet. He will testify that that was there before 2011. And then an upstairs area, storage area of about 208 feet, which he will also testify was begun before you say that they got married. But more than that, so that's why that fails. Can't show that the community contributed, made an economic contribution because there was no community funds. Can't argue that it was made during the marriage. My client's going to testify that it was made prior to marriage. There is a tax receipt that shows that, it's a tax statement that shows that an improvement was made in 2015. But if you look closer at that, it says it's effective in 2007. Mr. Martinez will explain to the court that the reason for that is because they did not begin they didn't find out about it until 2015, and they didn't start taxing him on it, that additional square footage, until 2015. Aside from that, even if she is able to show that those expenditures were made during the marriage, the Supreme Court has ruled since 1982 that it is the burden of Ms. Guajardo into pleading and proving the expenditures improvements were made by the separate estate or the community estate, and they are reimbursable. There is no other evidence than that tax statement, which does not conclusively show that the improvement was made in 2015. Going further, even if the judge Your Honor accepts this claim of reimbursement, even if you stated, as the case law is very clear, the measure of the value of this claim is the enhanced value from the time the alleged contribution was made to now. So the case law will show that the party seeking the reimbursement must prove the enhanced value specifically attributed to that particular adding of the square footage, to that square footage. Not that the property has improved because of market conditions, the property has improved because they added a fence. No, what is the enhanced value in 2015 to now? I haven't seen Mr. Salazar provide any evidence.
I do recall that the standard of that I've given Mr. Salazar plenty of time for him to put his best foot forward. But I do recall that the case law and the statutes do require proof of the enhanced value of the contribution to the total asset, For example, if the house was worth $10,000, they added another room together, she expended some funds, the house is now worth $30,000. So as a result of that addition, it's the $10,000 that's the play, because that is what is alleged to have been the net effect of the improvements as far as enhancing the value.
Well, this is the example that the appellate court has used. Wife alleges that the property was worth $10,000 when they got married and now has a value of $50,000. She argued that the community was entitled to the $40,000 difference. The court ruled that that argument fails because it fails to account for the value of the property at the time of marriage and the enhanced value specifically attributable to the community expenditure. Without such evidence, the trial court was justified in denying her claim for reimbursement. So first of all, in that case, it was the right pleading of the right reimbursable claim. But even further, Judge, if you go to their own appraisal, which I'm assuming Mr. Bruce is going to be called as the witness and I'm going to be able to cross-examine him. He's not designated as an expert by Mr. Salazar. Initial disclosures, the new laws require that experts be designated 30 days prior to. And this was not court appointed. I asked for court appointed and you said no. You wanted Mr. Salazar to obtain his own expert since they would be paying for it. So this expert's not designated. I don't see him on the screen, but he does include, as Mr. Salazar stated, the depreciation value of $49,480 because of the unimproved area. That goes against this notion that that addition of that area has improved this property when it's actually devaluing this property because it's incomplete. For that reason, I think it's important, knowing Your Honor and your eye for real estate. I think when you see this neighborhood and you see the video of this neighborhood and you see the video of this unfinished area, I think you'll agree with me that to that extent, it is actually devaluing the property rather than enhancing his separate estate. Yeah. So for those reasons, Judge, because any judgment that she could render with regard to a community property reimbursement claim is not pled for and would not conform to the pleadings that are on file before us, I'd ask the court to deny that. With regard to the one that is pled for, she's provided no proof that her separate estate expended funds on these improvements.
All right, thank you. All right, hold on, Mr. Salazar, before you respond to that. Let me get back to the other one. Mr. Freeble and Mr. Camarillo.
Your Honor, I have submitted a new calculation. Basically, the old calculation was based upon the deposits before I gave him credit for half of the deductions on his 2020 1040. So if you were to put that 19,851 back into net disposable, that's where you got the 4,466. So I recalculated it based upon giving him the credit for the business expenses, for half of the business expenses from his 1040, and you come out with the 2,811.75 monthly earnings. So the monthly child support would be $433.50. And I apologize to the court for that error.
No problem. Mr. Camarillo?
Yes, sir.
$433.
I also sent you what I'm making right now because I no longer work at that job. I was doing a 1099 at the time, and I have since quit that job, started my own company. And I did send you my profit and losses so far for the last 3 or 4 months that the
Well,
company
we're
has
gonna,
been open.
what do you think you can pay, Mr. Camarillo? You're gonna have to pay something.
Right, right. And I want to pay what's fair. That's the reason why I sent you all my
Well,
documents.
this is what I think is we're ending up at fair. I mean, it was $600 before you got here this morning.
Right.
We're
Well,
back-
he was also basing that off. They're trying to claim that I made more, and that was before my company deductions. So he's taking 50% of my company deductions, and halving it basically. So I really didn't make that. That's not profit. He's taking half of what my company costs to run.
Your Honor, what I am doing is taking 50% of the expenses. For instance, he's taking 100% of his fuel expenses for a vehicle that he used for his personal projects as well.
No, sir. No, sir.
Additionally, meals and so on and so forth. He has deducted all of that, and I am giving credit based upon the testimony of my client for 50% of those claimed expenses.
And he wants 100, right?
Well, I just want fair, because 50%, that's a lot. 50% is a lot. And I run an F-350 dually, and I'm strictly mobile. So everything I do, I'm on the road. A lot of that food charge, gas station food. I don't even go eat, I don't sit down to eat. I'm in and out, fueling up, getting a burrito, $2 or $3 here, drink, because it's hot outside.
Your Honor, our position is, how many times has the court seen somebody suddenly become or underemployed as a result of the filing of a divorce proceeding? Mr. Camarillo was employed. He was making money. He was, in addition to his employment with an employer, he was self-employed. The divorce is filed, and suddenly he picks up with the large majority of the community assets, goes off to Pearl Land, starts his own business, and claims that he is making no money whatsoever, leaving my client and the child here in the Cameron County. And by the way, we have asked for retroactive child support since the date of separation in May of 2021. He has paid a total of $700 in child support. So I don't believe that Mr. Camarillo's position is well taken.
Well, one thing I do know is that he has to support his children.
Correct. And I'm trying to, and this is the reason.
But I do not think that we want to set anybody up for failure, because we're going to be right back to square one.
Yes, sir.
So it's going to be an amount that is fair, and it might not be everything you want, Ms. Crow, or not everything he wants, but it's going to have to be an amount your child needs support. There is no doubt about that. What about the insurance?
My client maintains health medical insurance at a total of $80.01 per month.
Is that through the CHIP program?
No, sir, that's through my employer.
He needs to be reimbursed for that too.
Okay.
Did you deduct the payment of the insurance from him at $80?
Yes, Your Honor. I have sent that to your court reporter. That calculation.
Camarillo, this is what I want to do. Because of the fact that you just sent me some more stuff that I need to review, I like to not only slowly deliberate these matters, but also review what I have in front of me so I can be informed, so that I will be able to justify my actions to all of you as to where I want, what I leaned on to be able to make that decision, right or wrong. Okay?
Yes, sir.
But I will make it. So what I want to do is I'll reset this for Friday. It's just for the basic, or I could just give you a written opinion, a written notice as to what I think the child support is going to be, or what I'm going to set it on.
Your Honor, I'm scheduled for depositions tomorrow morning. If I can prove up the divorce,
Yes.
the court has the.
Yes, go ahead and proceed, and then that way I'll send you a letter ruling to your respective addresses once I review all that information. When did you already send it, Mr. Camarillo, the email, the information?
Yes, sir.
You have it, Ms. Carranza?
Yes, I got it.
All right. Well, let me put it this way. Let me do it till Monday, because I got a lot of stuff going on this week here. So it gives me an opportunity to get those documents And then on Monday, I will issue a written opinion advising you as to what I think the child support should be in this case. Okay? And I'll
Yes, sir.
review everything that you have, Mr. Friebel, including your recalculations. All right, proceed. Ms. Crowe, raise your right hand, please.
Raise your right hand, ma'am. Do you solemnly swear from the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand up.
Would you state your name for the record, please?
Taryn Lee Crow.
And you are the petitioner in this divorce proceeding?
Yes.
Prior to the filing of the divorce proceeding, were you a domiciliary of the state of Texas for the preceding 6 months and of Cameron County for the preceding 90 days?
Yes.
Are you requesting divorce because the marriage has become insupportable due to discord or conflict of personalities, which destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation?
Yes.
You were married to Hiroshi Guadalupe Camarillo on or about February 12th, 2021, and ceased to live together as husband and wife on or about May 9th, 2021. Is that correct?
Yes.
There was one child born to you and Mr. Camarillo, Ronan Paul Camarillo, a male born January 28th, 2014. Is that correct?
Yes.
And you were requesting the court to appoint you as the primary conservator of the child, to make you and Mr. Camarillo joint managing conservators, with you having the exclusive right to establish the residence of the child without regard to geographic location. Is that correct?
Yes.
During the marriage, certain community property was acquired, and you were requesting the court basically to award the personal property to the party in possession. Is that correct?
Yes.
Specifically, there was the F-350 dually, which you have allowed Mr. Camarillo to have, the RV, which he is currently living in, which you have agreed he is to have, the trailer, the moving trailer that he is, you have agreed that he is to have. Is that correct?
Yeah, it wasn't a dually, but yes, that's correct.
And you are just requesting the court to make a determination of the amount of child support. Is that correct?
Yes.
Are you requesting the court to restore your prior name of Taryn Lee Crow?
Yes.
And are you requesting the court to grant you a divorce?
Yes.
I'll pass the witness.
Mr. Camarillo, do you have any problem with the divorce?
Just the date. That's it.
What's the date? Tell me.
Basically, she wanted space on 5/9/21. That's when she removed from household, and I did leave for a period of time just to give her space as she wanted, and I came back the next month trying to work things out. We had discussions about working things out. We were going through therapy. Then, everything just dropped, and that's when I asked for divorce on 5/8/21.
All right. Other than that, any problems?
If I may, I do. We are requesting retroactive child support. Mr. Camarillo has paid the sum of $200 on November the 22nd, $350 on December the 13th, and $150 on January the 24th. Whatever amount the court determines to be the child support should be retroactive to June 1st of 2021.
Gotcha.
I'd like to add that I did pay for the rent utilities while we were separated. I don't know if that has to do anything with the child support or credit or anything like that.
Is that true, Ms. Crowe?
He was living in the house, so yes,
I know, but
he was paying for what
he paying the
using.
bills? Was he paying the bills?
Yes, for what he was using. I was not living there. We have been separated since Mother's Day, May 9th. We never moved back into each other, in with each other.
Okay.
And like I said, I left for a month. I wasn't there for a month. So I was actually 2 months. I was paying for her rent, utilities, and I still paid the internet until 11:09:21.
Okay, thank you, sir.
Yes, sir.
All right, the court will take judicial notice of all documents on file. In this case, the court will find that it has jurisdiction by virtue of the domiciliary requirements. The court, having heard the evidence of petitioner in support of her suit for divorce, hereby grants the divorce is paid for. The court hereby approves the division of the assets as stated on the record. The court here will restore the name of Taryn Lee Camarillo to Taryn Lee Crow. The court will approve the appointment of both parties as joint managers and conservator, with Ms. Crow having the right to designate the primary. However, the primary will be restricted to Cameron County. Ms. Crow, if in the future you feel that it's necessary, you have a tremendous opportunity facing you in Illinois or wherever, and your child's life is going to be improved as a result of that opportunity, you can come back to me and I will give you permission to move.
Thank you.
But it's got to be justified to me before you move out of the area, okay?
Yes, sir.
Your Honor, the reason I was asking for no geographical restriction is because Mr. Camarillo has moved to Pearland.
Right.
Just between Houston and Galveston.
Right.
If my client were to move any place north of the Rio Grande Valley, it would be closer to Mr. Camarillo.
Well, if that's the case, then we won't have an issue, right? I would love for that child to be close to each other, to the both parents, you know, so they can have the benefit of both worlds. That would certainly be beautiful, and would tell me that what really matters in this whole thing now that you don't have a personal relationship with each other, the most important thing that is on your plate right now is the upbringing of your child. And in my book, you know, I've seen too many of them where they raise with one parent only, and it just doesn't work. Somehow or another, it just doesn't work. So I encourage that. So, but if that's the case, Ms. Crow, if you're gonna move closer to Mr. Camarillo, then of course I'll bless it, because I would allow him to see your son, the son, and be part of his life. Both of you will be part of his life. You'll be much closer. You don't have to. This is not about you. This is not about your relationship. It's over. I just terminated it. I just gave you a divorce. So it's not about you. Because I know, I'm confident when I tell both of you this, is that if you were called upon to give up your life for that child, you would do it in a heartbeat. Both of you. And to me, that signifies a lot of love for that child. So it's out of that love that I'm asking you to cooperate with each other. If you in fact move over there, don't think about you and him or her and you. It's not about you. It's about raising that child the right way and giving them all the resources and ability and chances in this life to succeed. That's what it's about. Keep your eye on the bouncing ball, okay?
Thank you, Your Honor. May we be excused?
Yes, and you'll have my decision regarding the child support on Monday.
Thank
you so much. Thank you so much for both of you for being here.
Your Honor, this is Steve Estimia. Can I make a very quick announcement?
Yeah, as soon as I finish here. Mr. Garza, Mr. FMU, and everybody else, what do we have?
Yes.
We're just asking that maybe a couple of weeks, because we have some differences on the numbers and we need to get together in person, see where the differences are. Instead of wasting the court's time.
All right, Mr. Garza, is that correct?
Yeah, I discussed that with my client. She has no objection, Your Honor.
All right, how long do y'all need?
2-3 weeks.
Couple of weeks?
Yeah.
Huh?
Yes, sir.
Yes, sir.
Okay, give him a couple of weeks.
Let's set it up for February 15th.
Thank you.
At 8 o'clock, Judge?
Thank you all. Have a good day.
Thank you.
All right, let me get on to the other one. Fajardo, Ms. Rodriguez, and Mr. All right.
Judge, may I respond?
Who is going to testify on your behalf, Mr. Salazar?
Ms. Guajardo.
Do you have any live witnesses?
Ms. Guajardo, she's on the screen.
Okay, and you, Ms. Rodriguez?
My client, Mr. Martinez, is present.
All right. And what are we gonna do about the appraisal, Mr. Salazar?
Well, I wanted to show the appraisal as an exhibit, Your Honor, but I just wanted to respond at least very quickly to the petition that Ms. Rodriguez was mentioning, we did file a petition, an amended petition, November 23rd, that has the language as far as reimburse the community estate for assets expended by the community estate for the benefit of respondent estate. So on that regard, I think we can move forward with the right petition and the right argument as far as arguing that this improvement to his property was done, what should be reimbursed to the community. As far as the marriage, the court already ruled that this marriage was a valid marriage since 2011 moving on. There's no rule that community property exists only if they have joint bank accounts. That's, I mean, I believe that's a faulty argument. There is obviously a fact question as far as when the improvements were made, but I believe that, you know, the county clearly states 2015 is when those improvements were made. From my experience with property with the Cameron County Appraisal District, if you build even a small shack, they're going to tax you on it. Aside from the fact that Ms. Rodriguez owns exhibits, do have a receipt for 2019, which lends more to closer to the date of 2015 as far as when those improvements were made, and Ms. Guajardo's testimony to that extent.
Look,
And in
the evidence that the court is relying on is what was produced at the same time that your client testified that when they started building, that she was helping, that her brother came and helped him erect the walls, things like that, and that at that time they bought some stuff for the house. If I remember correctly, I'm not quite sure about that, but that's what I'm basing it on. If the property is Ms. Rodriguez's separate property, her client's separate property, and whatever work was done during the marriage, that is done by the community. It doesn't have to be done on money-wise. If one of the parties spends from sun up to sundown improving the property without either doing it himself, cleaning it up, doing all that are designed to enhance the value of the property, that is community labor. H1's work effort is community labor, whether compensated or not. So if there's community labor involved in enhancing that, the court certainly is open to receiving that evidence for reimbursement of a separate estate, a community estate enhancing a separate estate of Ms. Rodriguez's client. How much enhancement it is, that's what the other thing. We have to go visit the formula that has been set down by, I don't know if it was set down in Eggemeyer or Malone or any of those dinosaur cases that are still around and are still relevant in the family code that talk about reimbursement, community reimbursement. Those are the ones that come to my mind, but there's several other ones that were notorious at the time they came out, and I think that they're still the law that's being followed right now. So that's where I'm coming from. But the reimbursement that she's gonna get is not going to be thousands. But she is gonna get some reimbursement. So your testimony this morning included to the personal labor efforts of the community, whether it's in the form of money or time and toil and all that, because that is also community. The time toil of the spouses is community. I don't think any of you have a dispute about that. That's the way it's defined. The time, toil, and effort of individual partners is community property. So that's where I'm coming from. Regardless of whether there were any actual monies put into the property. If she worked out there helping him draft up the wall through herself, called her brother up, and they were all out putting the walls, that's community labor. If he was out there doing and enhancing on some property, that's community labor. Once having found that there was a marriage. So whatever efforts were expended on that house after 2011, that's all community labor, and it was designed to enhance his separate property. Whether one room was built, whether half a room was built, or whether all the rooms that were built were unfinished, it doesn't matter. The only thing that matters is the valuation of those unfinished structures. Ms. Rodriguez is correct in reciting the law. I agree with that, that it's not a plain vanilla, well, this is what the house was worth back then, now it's worth this much. That's not what the burden, that's a proof requires. That's not what the law requires. It requires you to show me from the time that they made their effort, what was the value of the enhancement to an already existing asset, not what the appraisal district appraises it for. Not the difference between the appraised before and after. That doesn't get me there. It doesn't get me there specifically with her contribution. That's what we have to value. If as a result, if they raised 3 walls and they needed 4 walls and they raised 3 walls and somebody comes and appraises, well, now it's not worth 0, now it's worth $100. That's the enhancement. That's the way I read the law. Now, I stand to be corrected, but that's how I recall it as recently as last year. So maybe things have changed since the last time I opened the family law code, but it is, I stand to be corrected. You let me know.
No argument there, Judge. And as far as the enhancement back from since 2011, truthfully, all we have is Ms. Guajardo's testimony. She would give him any money that would be used for purchasing material in cash. She wasn't planning on all of this, so she didn't keep any receipts, any detailed diary. So we have her testimony as to the improvements and the value that she put in her estimates on that. No, we don't have any, truthfully, Judge, we don't have anything else because the proof just is not viable for us to.
She didn't keep it.
As I understand, though, that is the exact opposite of what you just said, Judge. It's the enhanced value, not the contribution. So the testimony
yeah, if you put a dollar value on that, Mr. Salazar, on what your client is going to say, I gave him what, $2,000 for materials and things like that. All right, that's the cost, the actual cost. Once those $2,000 were put in that structure, in the home, in this case, how much did those $2,000 and that labor that went into implement those changes, how much did that add to the value of the total asset? So it's broken down. You have a basic structure. I want to add a room. You want to know how much that room enhanced the total value of that asset. So the house by itself was worth $10,000. Now that you add a room, it's worth $15,000. So now we know that $5,000 can be attributed to the new room, right? Something like that. That, I believe that's what the burden of law of proof requires. Something like that.
Yes, Your Honor.
And that's why I opened this thing up, because in my opinion, after listening to all the evidence, after coming down the way I did, and decided that there was a marriage from 2011, I also knew that there might be some reimbursement claims based on what your client, Mr. Salazar, had testified to. The purpose of this hearing is to refine that testimony and then tell me, as a result of the improvements where she donated money, where she gave money, where she donated personal labor, or her brother donated personal labor on her behalf, what was the improvement and how much did that add to the value of the whole asset? That's where I'd like to go, because that would be consistent with the rule of law. That's consistent with what I believe to be the state of the law in reimbursement claims. Unless you tell me I'm wrong, Mr. Salazar, like I said, I stand to be corrected.
No, Your Honor, I do not disagree. And as far as the guidance to that, in page 4 of the appraisal, there is a note from the appraiser stating living area adjustments are based at $60 per square foot. And that's the guidance that we are going to argue that if she in 2015 throughout the marriage helped attribute 680 square feet to the property. And if we value it in the living area adjustment space at $60 a square foot, you know, the math does work out to $37,000. And excuse me, I have it here.
What,
Judge, that doesn't.
but
give
I
us
need
the
proof that
value.
I need proof that those resources were put into the totality of those 600 square feet. You understand what I'm saying? Because
Yes,
I'm going to give her credit for whatever. Well, I contributed some, but we put up a wall, but that's all I did. Then he comes later and then puts up the other wall. Then I still have to divide her reimbursement even further, because the whole effort wasn't hers. It was his and his resources to put up the other 3 walls that allowed it to come out to that $60 per square foot. Do you understand what I'm saying?
I understand. And if you allow me to just.
I'm glad you do, because I think I just confused myself.
This is very
Maybe I don't know what I'm saying, but I think you got the gist of it.
Yeah.
No.
Well, Your Honor, I agree with the court's analysis, you know, on how to arrive at the value. I think what Mr. Salas, well, we dispute that capital improvements were made during the marriage. That is one thing my client will testify.
I understand that.
And we will argue that when Ms. Wahadlo testified about her brothers helping, she testified that her brothers helped build the house when it was initially built in 2007 to amplify her claim that they were married, not that they made contributions after. But her brothers are not the community. I understand where the court's going with that. But further, Judge, I think what Mr. Salazar is missing is that link of, you know, we dispute when the contribution was made. And if he's going to argue that it was made in 2015, then the Supreme Court requires us to have a value in 2015. That is Mr. Salazar's burden. You can't, like you said, you can't simply say, you know, it was worth in 2011 X amount and now it's worth this. You've got to go back to the time that the contribution was made, determine what that value is. And I know it seems impossible, but that's the standard. And to what it is now and how that contribution.
It's a matter of you getting the appraisal district the appraisal right before that.
Right, but in the appraisal district.
That is some proof, the appraisal before that and the appraisal after that.
But the appraisal.
I mean, it's some proof.
But the appraisal district is not, numbers aren't going to work, because you'd be comparing appraisal district numbers to a market value appraisal. It's either got to be
I understand that they're apples and oranges when it comes to valuation. I understand that. I understand that. But I'm saying that is some proof of enhancement. Whether the appraisal numbers are totally different than the market values, I agree with you. That is accepted in the industry, that, you know, what the property is appraised is not what the market, what it would sell. Sometimes they're appraised higher than the market goes, so it's over appraised. I don't know, but I do agree with you that there's a difference in the market value as opposed to the appraisal value. But what I'm saying is that will be some proof that there is a change in the value, whether the value is appraisal or not, by getting an appraisal of the year before and an appraisal of the year afterwards, because this properties are appraised every 2 or 3 years, I believe. That's when the tax man comes around your house and puts your dog to sleep with a tainted dog bone, so they'll go to sleep so they can go in the backyard and look and see you're not building anything back there. You know what I mean, Ms. Rodriguez?
Well, we had the CAD appraisals up on the screen at one of our last 5 final hearings. We had it up on the screen compared from 2015 to now. And I think it went from like 56,000 to 60,000 or so. I can't remember. Maybe it was a $10,000 increase, but that was CAD to CAD.
Yeah.
You know, apples to apples. And that wasn't good enough for Mr. Salazar. He needed the fair market value now. But what we don't have is the fair market value in 2015. And the CAD appraisal, the fair market value appraisal is double that. I mean, it's done. And where's Mr.
Let me,
Bruce?
yeah, I understand. Send me to a breakout room with Mr. Salazar and Mr. Rodriguez for a second.
Okay. Okay. It's open.
Did my client leave the Zoom hearing?
I don't see her on.
Let me get her called. Judge, in case I can't get her back, can we move forward with this or?
You're muted, Judge.
I guess we forgot to tell her that not to leave.
Well, she was here for a while. She just must gotten off.
Okay, can you reach her, Mr.
Yeah, I'm having my paralegal give her a call right now.
Okay. Why does Mo have two things?
Because he has one at his desk and then he has the one behind my seat in the courtroom in case we have people that come in live person.
Should I enhance my Zoom experience?
No, don't touch anything on your screen.
Thinking and saying, come on, hit the button.
Don't touch your screen.
Get a hold of her, Mr. Salazar.
Guys, were you able to attend Annabelle's service?
I saw you on the screen.
Oh, I didn't see you. Wasn't it? Well,
My apologies, Judge. She thought it was over. She's gonna log in just now.
Okay. Yeah, I was there. Sorry to see her go, man.
so, yes, very sad. Such a great person, great attorney. I learned so, you know, she was the amicus in that first jury, my first jury trial was with you. And she was the amicus in that one.
Yeah.
And when we did the divorce, she was also the amicus, and that was my first bench trial ever, and it was with you. And man, she really walked me through that whole ordeal.
No, I knew she was, I found out that where she had gone to school by accident. When I first ran in 2013, I had already had my dealings with her. She had mediated some stuff with me, and I had gotten to know her there. And when I ran, I saw her here at the courtroom, and I remember like it was yesterday. She was sitting there out there waiting for something, and I come up to her and say, "Hey, what's going on? How are you?" "All right." I said, "Well, listen, I've made a big decision." I said, "Yeah, what is that?" I said, "I've decided to run for district judge." And she went like, "What? You?" I said, "Yeah." She went like that, "You?" I said, "Yeah." I said, "Who?" I said, "Annabelle, who else better than Mr. Effervescence himself?" And when I said effervescence, she just almost fell off the bed. She started laughing and said, I said, "Come on, man. You don't think I have a bubbly character, a bubbly personality?" And she said, "No." I said, "Okay." Well, should I ask you for your support? She was funny. Ms. Guajardo,
Yes.
sorry that we were not clear enough for you not to leave. We were not finished. We were trying to discuss this matter. You've had an opportunity to discuss the matter with Mr. Salazar, your attorney. Is that correct?
Yes.
All right. So as I understand from Ms. Salazar and Mr. Rodriguez, that the parties have agreed to resolve this issue for the amount of $4,000. There will be the representing the reimbursement right of the community, of Ms. Guajardo's share of the community that she may be entitled to as a result of the improvements on the personal separate property of your client, Ms. Rodriguez. The question now becomes is, Mr. Martinez, I need to know, I need to hear from you. What I need you to Mr. Martinez.
Yes, sir.
Good morning.
Good morning.
I need you to tell me at what rate and monthly rate you can pay the $4,000 judgment to Ms. Guajardo.
I'm on, right now I am on,
I know that you're on Social Security, disability, whatever. That's why I'm asking you the question, since you know what your income is and what
He works too.
I'm getting, so much amount. How much? I think it's 840. 840 a month. And, I could do 50 a month right now, and hopefully in the, afterwards, a couple months I can do more. Or I can even do, if I get something, I can even do more than that. So saying that, Your Honor, I will try to get that money paid off as soon as possible.
Well, here's what is going to happen. If I enter the judgment at $4,000, the sooner you're paid, the sooner you'll be out of it, and the less interest you will earn. So you need to get on it. Yeah, you need to get on it and pay her as soon as possible. So when you say $50 for the beginning, for how long?
Maybe 2 months, maybe on the next month I can pay more.
And then when you go and you increase it, how much more will we be looking at?
Like I said right now, Your Honor, I want to try to pay it as soon as I can. If I can pay it within 6 months.
So if after 3 months I increase it to $100 a month,
I will work with that.
okay.
Yes.
Here's the thing that you have, Mrs. Guajardo, before you shake your head. I can do it this way. I can give you the judgment and I can let you go resolve it yourself.
Well, it's because he gets retirement and he's a manager of the apartment, so he's working. He has plenty of money to pay me back. And I have his paychecks if you need them, where they send him his checks.
All right, Mr. Guajardo.
I mean, I put all my kids, my disability, my niece disability, my daughter's child support, everything. I was getting almost $2,000 a month in the house, but that's fine. God sees everything. I wasn't living there for free.
All right. I know, ma'am, your testimony and all that, but the proof is lacking under the law, and I'm trying to resolve this in the most equitable way I can. If you're not happy with the settlement, you tell me right now.
No, I'll accept it because I want this over already.
Okay. All right. There you go, Mr. Salazar and Ms. Rodriguez. Draft up something that will be consistent with what we've talked about here today.
Okay, Mr. Salazar, I think just needs to prove up the divorce.
Yeah, and just to be clear, the interest rate, Your Honor, is
that's statutory.
Statute. Yeah, just making sure.
Yeah, whatever the statute says.
Understood. All right. Yeah, we can prove up the divorce for Lisa's, you know.
Raise your right hand, Ms. Guajardo.
Do you solemnly swear from the testimony you would be the truth, the whole truth, and nothing but the truth, help you God?
Yes.
Thank you.
Ms. Guajardo, please state your name for the record.
Olga Guajardo.
And you are currently married to Juan Pablo Martinez?
Yes.
And you've been domiciled in the state of Texas for the preceding 6-month period and a resident of this county for the preceding 90-day period.
Yes,
And the court has ruled that you've been married since 2011 and ceased to live together as husband and wife on April 2021.
yes,
And the marriage has become insupportable because of discord and conflict that destroys the legitimate end of the marriage relationship with no expectation of reconciliation.
yes.
And there were no children born to the marriage, none adopted and none accepted. Is that correct?
Well, he accepted my daughter as his daughter, but no, I guess.
So again, no children between both of you.
No.
As to division of the community estate, you have agreed to get reimbursed the $4,000 by Mr. Martinez at $50 a month for the first 3 months, $100 after that, incurring the statutorily allowed interest. Is that correct?
Yes,
And you're asking the court to grant this divorce as stated.
yes,
Nothing further. Your Honor.
Court will take judicial notice of all documents in this case. The court will find that it has jurisdiction by virtue of the domiciliary requirements of the family code. The court, having heard the evidence of petitioner in support of her suit for divorce, hereby grants the divorce as prayed for, and orders the division of the assets stated on the record, and orders the judgment be granted in terms of, as previously discussed, in the amount of $4,000 in favor of Ms. Wajago and against Mr. Martinez. Anything else?
No, Judge.
That's all I have with the court, Your Honor.
Thank you.
And Judge, may I be excused?
Yes, ma'am. Thank you.
Likewise. Thank you.
Thank you, sir.